Okay, let us start. So today what I'm going to do is give you a overview of the various aspects of intellectual property rights. So it is only a very preliminary kind of talk to give you an idea what are the different types of intellectual property and what are the kind of protection that is available for each of these different intellectual properties. So having said that, it is a very fundamental and preliminary talk. It is not going into the details of how you are applying for a patent or how you are applying for a trademark or a copyright and so on and so forth. It is only to give you a basic understanding and overview. So I have to tell you upfront about that. And it's a very fundamental thing, but then we can definitely have a discussion on the various nuances and various doubts that we have. So I will quickly run through the slides and then we can go ahead with the this thing. Now, when did intellectual property become an issue? Well, we have heard about the classics and religious texts, Bible or Bhagavad Gita or Puranas and all. People have been reproducing them from time immemorial. We do not even know the exact historical date when that book was written or then when that book was conceptualized and so on and so forth. People have been kind of copying, reproducing, applying it for centuries or rather millennia. But towards the end of the 17th century, what happened is that the Gutenberg, you might have heard about the printing press by Gutenberg in Germany. So books started getting printed. Probably they started with Holy Bible or so, but then subsequently it led to books start getting published, printed, newspapers and gazettes and small reports being published, industrial documents that started getting published, and it also coincided with the industrial revolution, the steam engine, and people were starting factories, mass production, mass customization and so on and so forth. So in such a situation, it became necessary that they needed to protect the author's credentials and the author's right to preserve the identity of the author in terms of the document. So that set the tone for the protection of intellectual property. It started in Germany in the late 1770s or so. It spread to other European countries which were the hub of the industrial revolution. United Kingdom, France and other countries. That was the developed world. America was still a colony of the British Empire, and nothing much was happening there. So that started the trend towards looking for some legal sanctity for the author, protecting the intellectual property of a person. Towards the late 18th century, around the 1980, all the countries in the world agreed upon various provisions for protecting the intellectual property. Then last 100, 250 years, there have been many agreements starting from the Paris Convention, Berne Convention, so many agreements that are being in force where there is a clear protection of intellectual property globally. Now you fast forward to today, the United Nations has got a body called the WIPO, World Intellectual Property Organization, which is actually protecting the intellectual property globally. It works with all governments. Every country, UN member state is a member of the WIPO or the World Intellectual Property Organization. The World Intellectual Property makes the guidelines, standards, the provisions, so that every national government is able to formulate policies to protect the intellectual property. So that is just to give you a perspective on the historical significance of intellectual property. Now let us actually see what is property. We know there are three types of property: movable property, immovable property. You have a car, you can move the car from Coimbatore to Kochi or Coimbatore to Bangalore, but you cannot move your land or your building. You have a building constructed in Coimbatore, you cannot shift that building to Kochi. So that clearly sums up the movable property and immovable property. But what is intellectual property? Intellectual property is some application. It could be a creative application. It could be a literary application. It could be an artist, a song or a book or a screenplay or a movie or an invention, innovation. And that is where we are trying to protect. And intellectual property is basically you are using your brain. It is a using the intellect, the faculty of thinking, the human mind is utilized, and you are creating something. This creation is intangible. It is not material. You cannot like a house. You say a house is 2,500 square feet. But you cannot, this is an intangible. You record a song. The song is available on some digital media. It is there on your flash drive or your audio cassette or your CD drive and so on. But it is intangible. And this creation of the intellectual property requires you to protect it. Protect it in a time-bound fashion, in a territorial fashion. And as the author, as the creator, you need to safeguard this. And we will see how this safeguard is happening. So this is the definition given by WPO. Intellectual property includes the rights for literary, like books, articles, research papers, artistic, scientific work, a song, or even why not even a podcast. That is also a kind of an artistic thing. Performances of performing artists, phonograms and broadcast, podcast, inventions, scientific discoveries, designs, trademark, service marks, commercial names, and so on. So this is the broad, the family that comes under intellectual property. Now we will see them, each of them in quick detail. The major intellectual properties are copyright and related rights. If there is a song sung by a singer, say Beyonce is singing a song, and that song is released by Virgin Records. So there are some rights given to Beyonce to perform it in several stages and programs. At the same time, Virgin Records, which has produced that label or that song, has got some rights to distribute it, to circulate it, whether it is through Apple iTunes, whether it is through Apple to Spotify podcast, or whether it through CD that are available on music stores, download, MP3, all that rights are given. So that we will be seeing. But primarily the industrial property, so copyright is generally for these kind of things. The other intellectual properties that we see are patents, which is very relevant to all of you as researchers, budding researchers, working on your doctorate, working on some intellectual property creation. Then to some extent, industrial designs that are used by companies for new methods, new processes, new products. Trademarks, they are the company's symbol, the insignia of the company. Anywhere in the world you see the Apple, this Apple thing is known anywhere in the world. You know where this Apple stands for, the logo stands for. That is a trademark. A geographical indication. People from Kerala know about what is known as an Aranmulla Kannadi. An Aranmulla Kannadi is an example of a geographical indicator. Only the people in that place in Aranmulla, somewhere in Kerala, they know how to make a kind of a mirror. That mirror is actually a metal alloy mixture, but it is so bright, it looks like a mirror. And people say a woman looks into the mirror, she becomes more beautiful. That is what people say in Kerala, having an Aranmulla Kannadi. That is a geographical indicator. Alfonso mango is a geographical indicator. Champagne, champagne is a alcoholic drink which is made in France, the district of Champagne in France. So these are geographical indicators. Then there are integrated circuit designs, topographies and layouts, which is more towards electronics, designing, fabrication and so on. There are trade secrets. There are trade secrets, like I told you the example of this Aranmulla Kannadi. It is a trade secret. Nobody knows the design of that Aranmulla Kannadi. Only that family knows how this Aranmulla alloy mixture is made. Similarly, there are many other kind of trade secrets which people do not want to know. Coca-Cola. Coca-Cola, nobody knows the actual formula. Only Coca-Cola company knows that formula. It's a trade secret. It is protected as a trade secret. Protection of new plant varieties. This is more towards the biotech side. When you are engaging in genetic modified crops, when you are doing some sort of biotechnology, bioengineering to develop new crops that are pest resistant or disease resistant, you make new you play God and you create new plant, but that you need to protect that also. So these are the broad categories of protection of new plant species, all the types of industrial property. And in India, see, I have already told you, any intellectual property is territorial, meaning you can only protect them within the territory of India. You have a patent in India, you can only protect it in India. You cannot do anything. Somebody copies your design in some foreign country and sells it, you cannot do anything. There is no legal protection that way. The only way is if you are having an innovation that is global in nature, you need to go for a series of patents. You need to go for a US patent. More or less, US patent is accepted all over the country, world. You can go for a European Union patent. More or less, this will take care of many countries. Maybe an Asia Pac Pacific, there are some Japanese patents. So it depends upon where your market is. But in India, there are several acts. There have been some amendments to all these acts. I have only listed the acts that are there. The Copyright Act by Ministry of Higher Education, Patents Act 70 by Industrial Policy and Promotion Department of the Government of India. This is part of the Ministry of Commerce and Industry. Designs Act, Trademark Act, GI or Geographical Indication Act. Then the Ministry of IT has made the Semiconductor IC Circuit Layout Act and the Protection of Plant Varieties by the Ministry of Agriculture. So these are the Indian kind of protection with respect to the various intellectual property. Now let us see what a copyright is. Copyright is generally used for any original, dramatic, literary, musical and artistic forms. So obviously there is an author, there is a singer, there is a writer, there is a dramatist or a playwright, there is an artist. An artist could be an actor or a singer or whatever. And there is some creation of some sort of a music video or a cinematograph, means it's basically a movie or a sound recording or a audio and MP3. All these comes under this Copyright Act: literary, dramatic, musical and artistic. Now, how do you protect this? There are two types of rights. There is a moral right to protect the personality of an author, and there is an economic right to bring economic benefits. Now, moral right, you can imagine, you make a huge, massive, that is, you are spending 100 crores on a movie, shooting in multiple locations across the world, hiring the best actors, hiring the best cinematographers, art directors, music directors, and so on. And one fine morning, you make a movie. When you are releasing it to OTT or you are releasing it to a theater, somebody just, does some sort of piracy and puts it freely on the internet in some of these BitTorrent or some free sites. I mean, the whole purpose is defeated. The moral right, the creator has completely lost it. Obviously, he needs to make money, but the whole thing is lost. So there is always a moral that, you have done it, you need the credit. Second thing is the economic to get the money. And moral rights is the authorship. Who is the author? Everywhere in the credits, everywhere in the credit, who has written it, and what is the integrity? You have the right to see. You have sung a song. Now you can change that. You have the right to modify it, manipulate it, and so on. You want to modify it, make it into a new style. All that thing is your inalienable right because you are the author. But economic is very, very, very dicey. Economic means the economic rights means the right of reproduction, making copies. You write a book, you want to sell, you print 1 million copies of that book so that you can sell it. You make, download from a site on payment, PDF file. That kind of is the right of reproduction. Right of distribution. You have a PDF, but you are not, or you have a book. You are able to put it in stores. You publish a book, you go to Higginbotham's, you put 100 books for sale, let them distribute it, you give it to wholesalers. Maybe you go to a college and say, okay, on college day, you can give this gift to all your award winning students. That is also a role, right of distribution, right of issuing copies, and so on. Then right of communication to the public. Obviously, when you make a creative thing, you have the right to promote it. Talk to the world. Hey, I have done this. It is my blood, sweat, and tears that I have made this intellectual property. I want to publish it. I want others to know, the whole world to know. I want people to buy the book, so that communication to the world. And now there is a added kind of complication through social media and internet communication. See, today we cannot we may love or hate it, but we cannot ignore the power of the internet and social media. If you take Facebook, today Facebook means around 2.85 billion monthly users are there. 1 out of 3 people on the planet have got a Facebook account. You cannot ignore this massive population. 1.5 billion users of YouTube are there. Can you ignore this? I mean, it's bigger than any media company in the world, YouTube or Facebook, right? You cannot ignore these kind of things. So that has become a massive channel for communication and for distribution. Adaptation rights, conversion of one form, literary to drama. You have written a book, you convert it to a movie. Let us take, Malayalam film Drishyam. It's a path-breaking, very small budget movie. The movie was made in multiple languages, 5 or 7 languages. I don't know exactly know. That is adaptation. You're converting from one form to another, either a book to a drama or a drama to another TV series. Now OTT platforms have come. You can have an OTT platform also. You can have a web series of the whole thing. That is the way things have moved. Then you can have abridgment. You can, have a prequel, a sequel. All those kind of things are adapting that movie or adapting that book, changing it, adding different styles to it, adding a prequel, something that happened before the story, or a sequel after that, so on and so. Having a picturization, a comic book series, all these are there. Similarly, translation, making it into a sound recording, a podcast, renting it, all this comes under economic rights. And that is why we need to have a clear understanding of the copyright. In terms of literary, the copyright is with the author. You have to be very clear. You write a book, you have the copyright. There is some agreement that you sign with the publisher, but the publisher has his own rights. If you have a drama, the dramatist, the person, the scenarist, the person who has written the drama, the playwright has got the copyright. Music is obviously the composer, not the singer. Please understand, not the singer. The person who composed the music will has the copyright ownership of the right, but the singer also has got some rights. Artistic work like a painter, sculptor, and architect, if you do something like that, they have the right. A photograph, the photographer has got the right. If somebody has written a computer program, that computer programmer has got the right. A movie, a cinematograph or a sound recording, the producer of the movie or the cinematograph or the sound recorder has got the right. So this is very, very clear in terms of the Copyright Act, who owns the ownership. Having said that, there are some exceptions also. Suppose you are working in Intel. Intel is paying for your Intel. It is very expensive sometimes to have Intel publish in the name of the company. So the employee who took the leadership, his name or her name will be there on the patent. But still, it is as an employee of the company. So there is some kind of agreement or some kind of arrangement between the employee and the employer. In many cases, that separate agreement will be there. The patent will be in your name, but the commercialization rights of the patent will be vesting with the employer, because your name is put because you have contributed, but you are given a salary for that. You are on their rolls of the company. You are paid for that. So that kind of agreement is also there. And certain cases, you give an article to the newspaper or a magazine. So as an employment by newspaper magazine, suppose you are a news reporter, you take out a story, you are an investigative reporter, you got a story, but that story, since you are employed by the newspaper, they have the right to, they have the responsibility and the publishing right. Similarly for the photograph and or a painting and cinema, as a person, producer, there are some rights, but then there are some exceptions here and there. If you are giving a talk, a lecture, the person who is giving the lecture is got the owner of the right. If it is a government activity, the government has the right. Public sector. If it's an international organization, if you are representing the United Nations and such, writing a report for the United Nations, how to reduce carbon emissions in India by 2030, that you are sponsored by the UN to do that. So that rights are not owned by you, but by the UN. So like that, some exceptions are there. The question papers, you are writing a question paper, you are creating one, that you have the right. If there is an encyclopedia, the person who compiled the encyclopedia has the right. And these are some exceptions. Okay. So securing copyright is voluntary, but it is always better to have a copyright. And all literary, dramatic, musical and artistic copyrights, it is the lifetime of the author plus 60 years. This is the general norm in Indian copyright law. All other works are 60 years from the date of publication. Even after the death of the person, 60 years. Works of includes anonymous works, works of government and organization. A government makes a report that it is the lifetime in terms of the copyright is 60 years. A cinema and or a sound recording, podcast and all, photograph 60 years. So this is the there are, as I mentioned, you are singing a song. Okay, there is a music composer who has composed the song. As a performer, you have some rights. You are allowed to because you have performed the song, the copyright is with the music label or the company or the composer, sorry. But even though the composer has got the right, you can perform it anywhere in the world because you have only sung the song, and that right you get for around 50 years. That is the performer's rights. Similarly, broadcasting. You make a movie, you sell it to Sun TV. The Sun TV has got the broadcast right for 25 years. They can show it any number of times. It doesn't matter because you have signed an agreement, and that is a broadcasting organization. So this is about the copyright. Copyright is very important, especially copyright comes mostly in terms of literary, dramatic, musical and artistic work, but it is important for us to know what it is so that we understand what. Now coming to the most important thing, which is probably most relevant to you, the patent. A patent, of course, is an exclusive right for an invention. Now that invention could be a product, it could be a new technology, a new process, a new module, whatever it is. But the idea is that this new product, new process, new technology, new algorithm, new thing, it is applied into something. That is a catch. Just because you have a new process doesn't help you. You make a new algorithm or a new process, right? Unless it is deployed into a product or it is able to do some technical function, some utility is there for that, it doesn't become of any use. It cannot be patentable. So a patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something and offers a technical solution. And the inventor, the right of the patent, which is normally 20 years, is that nobody else can knock it down. Another person cannot use your design and manufacture it. Another person cannot, you are protected by legal framework that another person cannot use your design and manufacture. Only you have the right. Now you can take the patent and sell it to a company, that is fine, but no other person without your permission, without your approval can manufacture that or deploy it into a product or into a technology, into a solution. Only you have that right. Obviously you can sell it to a company. You have the patent, you talk to a company, company will say, I will manufacture everything, but I will give you 5% of the sales. Something like that, some kind of agreement. It's a separate legal agreement, if you understand what I'm trying to say. Now, inventions, what can be patented? Any inventions in, obviously products can be patented, new products, new processes can be patented if they are very novel, new. If they are non-obvious, means it is not already there. It is something new. It is an inventive tech thing, something that is not there already. So either it should be very unique or novel, either it should be not there before, and finally it should be having some utility, some industrial application or some utility is what is expected out of the patent. And the grant of the patent is done by a national patent office. In India, there are multiple branches of this office. It's a long process. Sometimes it takes 2 to 3 years. There is a long series of steps. Generally, it is very difficult for a person to do all these things. So normally there are lawyers, intellectual property rights lawyers, patent lawyers, that they will take care of all this. You just need to provide the documents, the idea, without divulging too many details, and thereby you are able to do that. But that's a long process. I'll quickly run you through that process also. Now, what is not patentable? Many people think anything and everything is patentable, because I will tell you why. We, especially in the academic field, it's become a rat race, unfortunately. I don't know whether I should say fortunately or unfortunately. All universities, research institutions, colleges, they are all being ranked based on their creation of intellectual property. How many papers do you have? How many high impact papers do you have? How many patents you have? How many utility patents you have? How many design patents you have? How many are applied? How many are published? How many are presented? All this, it creates a rat race, and unfortunately, because of that, many people are just jumping the gun. Anything and everything they are trying to patent. And definitely patent office is aware of this. Now today there is a shortcut method. I don't know if many of you have heard. There is a scam called Australian patent. Indian patent may take 2 years, 3 years, 4 years, sometimes it takes, but there is a shortcut. There is a Australian patent. You pay money, you will get the patent. It is like publishing a paper without any thing and just paying money and you get the paper published. It's probably there is nothing in the paper, but you might have checked for plagiarism and so on and so forth. But having said that, there is a rat race, unfortunately, and because of this rat race, a lot of people are going for unnecessary patenting. Anything that is stupid, frivolous, something that is impossible, People are coming with these kind of wild ideas. Nobody can have a machine that has more than 100% performance. It is impossible. No machine will have more than 100% performance. But some people are coming with these wild ideas. You cannot have something that does not obey the Newton's law of gravitation. So these things are, people are coming with these stupid kind of ideas. Then anything that is harming the society and moral values. Gambling machines, slot machines. You've seen in Las Vegas, right? In US, it is legal and patentable. You can have a slot machine. In where is it? Las Vegas, Reno, and Nevada, and all these places. It's an industry by itself. It is patentable there. It is legal there. In India, it is not. Gambling is not legal in India. You are having devices to making a biological weapon, making a chemical weapon, making a gene that destroys the crops, that harms the society. All these things are not patentable in India. Now again, I told you, rat race. People are just taking, somebody gets an idea. That idea cannot be patentable. Some idea that is a scientific principle without any proving, you cannot patent it. You are making a new theory. You don't know whether the theory works or not. That's a different thing. You are proposing a theory. Obviously, you go through the motion of research by having a hypothesis, making a research statement, developing research questions, testing the hypothesis, going through that process, testing the hypothesis, doing a face validity. That process is there. But just proposing a theory, you cannot patent that idea, that abstract theory. Discovery of any living thing or non-living thing, substance in nature. Now, I'll give you an example here. People know about turmeric, right? Manjal. In Malayalam, we say manjal. Haldi in Hindi. Turmeric. Turmeric is known for your antiseptic properties. Now, your grandmother or your grandfather, when you were a kid, you fell down. They would have taken this haldi and manjal and put it on your wounded hand or your leg because it has got an antiseptic property. But interestingly, somebody in the US patented this. They extracted that antiseptic compound from the turmeric, and so this is not possible. Of course, it happened in the US, and I think Indian government through the WIPO had to object. There was another example, basmati rice. Basmati is a brand only available in India. Maybe India, Pakistan also. India, Pakistan, Bangladesh, these countries are the only places where this thin, long-grained rice called basmati, which is used for biryani. Only these 4 or 5 countries can, it is only grown here. But somebody in US did some genetic modification and created a similar and called it text matching. And he patented it also. So these kind of things are also happening. You cannot also patent some basic principle. You cannot modify a basic principle, law of gravity. You are making a new law of gravity. You have an idea. These things are not patentable. The mere discovery of a new form or of a new of an unknown substance which does not result in enhancement of efficacy, also you cannot patent. Mere discovery of a new property or of a new use of a substance. There is already a substance. Let us take the same manjal, the haldi, turmeric. You take turmeric, you apply it for cancer. I mean, already it has got antiseptic property. You cannot just use it for something else and say, I want to patent it. So these kind of things are also not patentable. Similarly, mixtures. You take so many, you assemble. You have 4 or 5 medicines. You have a paracetamol, a brufen. You try various permutations and combinations of drugs and make a new drug. That also you cannot patent. So you have many components. Like you take a bucket and fill it with a torch and say it is torch bucket. That also cannot be patentable. But sometimes you see some people doing these things. I don't know if you watch Shark Tank. You see all these kind of funny devices that people come with. But of course, many of them are not patentable. You can combine 2 devices together, right? That is possible. You can have an umbrella with a fan. People may buy the umbrella with a fan, but you cannot patent it. That is very, very, very clear. Okay, agriculture, new methods, horticulture cannot be patentable. Animals cannot be patentable except for microorganisms, other than microorganisms. But some seeds, variety, species, you can protect it as a plant variety. Mathematical method, business method, algorithm, computer program per se cannot be patentable. But if you apply this in a new scenario, right, that can be probably patentable. You write a new patent, you write a new computer program. That computer program has a specific application. Those kind of things may be patentable. I already told you about copyright and so on. Okay. Traditional knowledge is not patentable. I told you, same thing, this manjal or turmeric. Turmeric, being an antiseptic, no, you cannot patent, but people did that because in US they don't know about all these things. Government also has a tight leash on atomic energy. Atomic energy is a kind of a critical infrastructure in India because India is a nuclear power, a nuclear weapon state. So there is also some restriction in terms of patents with respect to atomic energy. Normally, this is only available in the government sector. Only the government is engaged in nuclear power manufacturing and all that. But all those are not protected by patents. If there is a private party doing something related to atomic energy, it is some sort of agreement between the government and that agency, and there is what is known as an NDA, a non-disclosure agreement. Now coming to industrial designs. So patent is what. Now I wanted to spend a little more time on one thing. See, as a research scholar, right? Please note, this is my personal opinion. Okay, this is just my personal opinion that I have. As a research scholar, definitely it gives you brownie points when you publish papers, when you publish patents. So always a question that comes, what to patent, what to publish, what to publish as a paper, what to publish as a patent. I know it's a very dicey, it's a very tricky decision to take because ultimately, you have milestones with respect to the research. You have milestones. I mean, you have a comprehensive viva, you have a qualifying exam, you have a open seminar 1, open seminar 2, you have 6 monthly doctoral committee meetings. All that is part of the game. But and every every milestone, there are some requirements. There are some requirements in terms of publications and so on. Now, a patent is a little different thing. You are patenting something, you cannot publish that in a paper. Then the whole purpose is defeated. So it's a very tricky kind of thing to decide what to patent, what not to patent, what to publish and what not to publish. There is no magic mantra. Let me be very honest with you. I'm very confidently telling you that nobody knows that magic mantra. There is no magic silver bullet for this. There is nothing. It's a decision that you as a researcher has to take. If you feel, yes, this technology that you are developing is got tremendous commercial value, right? Tremendous commercial value, then you should not publish because you have something that is going to be a game changer, that is going to be a winner in the business, that is going to make you a ton of money, maybe in the long term or the medium term. But having said that, if you are very confident about it, you should not publish that. But on the flip side, there are publication requirements. Yes, you can do something related to your work. See, if you are very clear that the main work you are not going to publish in, you can target normal journals and stuff and do some subsidiary work to your main research. Your main research, you keep it ready for a patentable. Only if you are very confident that it has got a commercial appeal in the future. But on the flip side, you have publication requirements. For that, you need to do something. The university guidelines are very clear. So you have to do, so you have to strike a balance. If you ask me, certain things you may be able to publish, certain things you may not be able to publish. But if at all you have something that is a sure shot winner in terms of commercial applications, you should just wait. But for publication requirement, you do some associated work. You know that, I mean, today with the internet and the explosion of information, you know, it's not so easy. It's difficult to, you know, the main work you go in one path, then you take a small deviation, do something, and that you can publish for the requirements of the degree and so on and so forth. But please note, this is only my personal opinion. Okay, I'm not talking on behalf of the university. I'm just giving you my personal opinion. It is a decision that you have to take. What to publish, what to patent, how much to publish, how much not to publish, how much to what to patent. All that magic mantra, you have to figure it out. Now, coming to the next type, that is industrial designs. Industrial design is a shape, configuration, pattern, ornament, composition of lines or colors, either in 2D or 3D. Now, see the design, see a bag, see how it looks, how ergonomic it looks like. These are all designs. There is clear design. It's a different type of scissor. It's a different type of bottle, a sanitizer, a chappal, or a what is that? Iron box. Pharmaceutical products. You see different types of capsules, different types of syringes, different type of vials for medicine. These are all industrial designs, which are kind of unique to a company. Textiles, you know, different types of textiles, right? All these are industrial, special industrial designs. Obviously, they have their own, they want to protect this industrial design, which is proprietary to the company. So who has, what is the right of the registered proprietor? Somebody who registers an industrial design, the proprietor will have the exclusive right to apply the design to any article in the class in which the design is registered. There is always a class. See, for example, jewelry. You have a design. You can say, I want to apply this design in the class of jewelry and in the class of textiles, right? I don't know if you see, I don't know, in the news, just Google and find out the Met Gala. There is something that happens every year in New York called the Met Gala. So Met Gala is a kind of a fashionistas. So some celebrities come with all funny kind of designs and dresses. Some of them will have jewelry. So you don't know whether it's a dress or a jewelry. So that is the meaning of the class. So the design can be used in more than one class. And the proprietor of the design has that exclusive right. And generally, the industrial design is protected for 10 years, and then you can apply for an extension of 5 years. Yeah, this is also similar. I'll come to the other things. Already this is told. Yeah. Yeah. What is not registrable? Some design that is copied, that is lifted, that is plagiarized, and so on. All these things you cannot register the industrial design. And you cannot also you cannot put some industrial design on social media and ask, give me feedback. Then you cannot, once you have done that, you cannot register the industrial design also. Again, you cannot combine other designs and make a new design. That is not possible. Anything that is vulgar, scandalous, or obscene, you cannot make as a design. These are all Indian regulations with respect to the industrial designs. And there are many things you cannot register. Calendars, certificates, forms, greeting cards, leaflets, maps, labels, tokens, stamp, religious symbols. You cannot show that as an industrial design. Mere mechanical contrivance, just making a contraption of some mechanical thing, you cannot show that as a registered industrial design. Buildings you cannot register. Flags, emblems of the countries, you cannot put an industrial design, and so on. So this is a list of things that you cannot register as an industrial design. Now coming to what has commercial value, the trademark. Now for trademark, I just need to show you some. Anywhere in the world you see this, you know what this is, Coca-Cola. Anywhere in the world you see this this Apple thing, everybody knows. It's a trademark. Toblerone is a pricey chocolate, Swiss chocolate. I think it's Swiss or French, I'm not sure. It's a Swiss chocolate, very expensive chocolate. So these are all trademarks, and these trademarks are registered. These trademarks are basically, graphically the good and the service or the good is described. And it could be a sign, it could be a logo, it could be words, letters, numbers, drawings, emblems, pictures, logos. It could be anything. But this is protected as a trademark. And nobody else can copy this graphical description. And again, the trademark has to be done in that country, every country. Suppose you are selling Coca-Cola in 193 countries, all 193 countries, you have to register the trademark. Otherwise, somebody else can sell in the same logo. So there should be every country has got a national trademark registry, and they have to update it. And normally the registration is for 10 years, but once you are selling products, you can extend it for indefinitely. Different types of trademarks are marks on goods, service marks, certification, ISI, the certificates are there, collective marks, well-known marks, trade names. These are the things. Service marks, some service marks are there, You see some logos of colleges, universities, finance companies. These are all service marks. There are some certifications out there. Ag mark certified, wool mark certified. Wool mark means it is some sort of gold. When you see this gold, what is that? Ag mark or something is there, no? Gold television ads of Kalyan jewelry and all, they'll say something, no? Some that is a certified trademark or is there. Collective mark is a little different. That is the members of an association or a group of people who are making something. That is a collective mark, like a society like IEEE or Institute for Chartered Accountants, Computer Society of India. That logo, that is a kind of a collective mark, a group of people, a society, an association, and so on and so forth. So trademarks, I told you, they can be visual, audio, even they can be olfactory also, smell. You have perfumes, right? Costly perfumes like Christian Dior or Coach, Fendi, all those kind of things also they do some trademarking. Obviously, state emblems, Indian Ashoka Chakra. The Indian Ashoka Chakra is the symbol of Indian government. You cannot trademark an Ashoka Chakra or something with the Ashoka Chakra. People have done that, but it's been it cannot be done. You cannot trademark something with the United Nations logo. These things cannot be trademarked. And then I told you the geographical indications of goods. I already gave you the example. It identifies goods as agricultural, natural, or manufactured goods that is originating or manufactured from a specific territory of a country or a region or a locality in that territory where there is a given reputation, quality, and characteristic. I told you champagne. Champagne is an alcoholic drink, very, very premium drink, but it has to be grown from the district of Champagne. I think the district is also called Champagne in somewhere in the south of France. Only then it can be called as a champagne. It has the grape. What is that? The grape, from grape only, I believe this champagne is made. But that grape has to be grown there. It cannot be grown anywhere in the world. I told you the example of this Aranmulla Kannadi. You cannot, nobody can manufacture it somewhere and say, even if he has stolen the formula. People have done that. I'm told people have stolen formulas and tried to, try to duplicate it, but reverse engineer it, but it's not accepted. So explanation clarifies that GI, the geographical indicator, does not need to be a geographical name, like Alfonso mango, most tasty mango that is there. Basmati rice, which is only available in the South Indian subcontinent, including Pakistan, Bangladesh, Sri Lanka, Bhutan, Nepal. No other place it is available. So if they are making something else, it's not possible. They are not supposed to grow anything. If they are growing some rice, they cannot call it basmati. So as far as the GIs are concerned, or geographical indication, in India also you have to register. You can register globally also. The registration is valid for 10 years but can be renewed indefinitely. This is what I told you. Somebody made Texmati. I remember in the US they were selling Texmati rice. They were saying it's like basmati grown in the US. But you know, the purpose was kind of defeated. I think the Indian government went to court and they stopped it or something like that. I don't remember exactly on that what happened. Coming to the end of the presentation, semiconductor integrated circuits, you can register IC designs, integrated circuit designs, which are proprietary. You can register them, and that registration is valid for 10 years. But it should be an original circuit. It should be something unique. It should have some commercial value. Means you are deploying that integrated circuit in some technology, some place, and so on. Trade secret, I already told you. Something that is very confidential, you cannot tell that. Anyway, that is GI to geographical indicator only in Goa, the state of Goa. People are very afraid that that formula, cashew nuts, it's based on cashew nuts if I'm not mistaken, and people are very afraid that that formula can be somebody can copy it. So they never allow that to be leaked out. But then unfortunately some Goan who emigrates to Canada, he knows the formula because it was there in his family. The trade secret is known to him. He can start off any beverage company in US or Canada. Nobody can stop him. But still there is a trade secret. You can register the trade secret. But of course, the trade secret has to be registered there also in the US or Canada if he has to do. So trade secret can be an invention, idea, survey method, manufacturing process. Like I told you, this Fenny drink, or this Aranmulla Kannadi, experimental results, chemical formula, recipe, financial strategy, client database. These are all trade secrets. And when trade secrets are used, when invention is not patentable, and these kind of places, patent protection is only 20 years. After that, the patent is off. So those kind of things you can protect through a trade secret. Finally, plant varieties and farmer rights. You are now doing a lot of biotechnology, bioengineering on crops to make them disease resistant, pest resistant. So then when you are developing using genetic engineering or bioengineering, you can always register the plant variety. And that variety should be unique, distinctive. It should not be similar to any other place in the world. And then this is done. Many agricultural universities, agricultural research stations and all, breeders, farmers, they usually register this plant variety. And it's generally 15 years for crops and 18 years for trees and vines. And the right of the breeder is that only he or she can produce it, sell it, market it, distribute it, export and import it. The farmer has some rights in the sense that he can sell it, he can use it, but if the farmer is not the breeder, there can be a difference. A group of farmers breeder can be different from a farmer. If somebody is a contract farmer, right, then he doesn't have the same rights as the breeder. Usually breeder and farmer are the same, but in some cases it's not also. Research, the researcher of the new bioengineered or biotechnology developed plant has got some rights, free and complete access to the material for research. He can develop the research, but authorization of the breeder is required when repeated use of such variety or as parental line is necessary for commercial production. If you are developing the research modifying the research of one variety of plant and making a new plant which has got commercial value, then you have to get the authorization of the breeder. So this is the kind of overview of the various types of intellectual property. Like I told you, in India it's not so easy. There's a legislative framework of IP administration. There are many. There is a separate for patents are separate. Trade designs are separate, trademark is separate, GI, geographical indicator is separate. Unfortunately, they all don't come under the same body, even though they come under the Controller General of Patents, Designs and Trademarks, which falls under the Ministry of what is that? Commerce and Industry. But unfortunately, you have to separately apply. Patent you have to separately apply, trademark you have to separately apply, design you have to separately apply, GI you have to apply separately, and unfortunately this process is a little long. It's very difficult for one of us to go behind this, so it's better to go into a lawyer. Actually, we can do this. It's not rocket science or something to file for a patent. Everything is available on the website, but that process is time consuming and requires a lot of engagement from your side so it's better to leave it to a patent attorney or a lawyer who will take care of that. He first takes the application form, checks the requirements, pays the fee, then normally you make an application, it is secret for 18 months, but then you can apply and say that I can't wait for 18 months, I want to get it published fast. Then you have a request for examination. So somebody from the patent office, an expert, will come and check whether your idea is new, novel and unique. And so this takes time. Period of 48 months is there for making this examination. 4 years. Nobody wants to wait for this, right? And this examiner will come and check. Examiner may find some queries and say, no, this is not okay, that is not okay, this is similar to something else that I have. They have their own patent database, so the examiner will be able to even say that this is similar to something, you please change it. So that process takes 4 to 5 months. Unfortunately, whole process takes 4 years to 5 years, but you can accelerate it a bit, and that is where the lawyer comes in. The lawyer knows the trick to when to go do what. There is a first examination report, then there is a public pre-grant opposition. Before you're granting the patent, it is published online so that others can say, oh, no, this fellow has copied me, and so on. So this kind of process is very time consuming, and unfortunately this is in Indian system is like that. So we can't do much about it. So I think that's all from my side. I'll be happy to answer any questions if you have. Thank you. Srini, are you here? Okay. Yeah. Yeah. Any questions? Yeah. Any other questions? I think you can unmute and ask. So I think you have the rights to unmute. Okay. Yeah.
Yes, sir. Prashant, sir.
Yeah. Srini. Yeah. I'm done, Srini.
Thank you. Yes, sir. Thank you, sir.
Okay. So if there are any more questions, no more questions, I think I'll close. Okay. Wish you all the best to all the research scholars. I'll send the slides to Srini, and Srini, you can circulate it to everybody.
Fine, sir. I'll circulate it, sir.
I'm just sending it to you. Okay.
Yeah. Yes, sir.
Okay. Thank you. All the best. See you. Bye-bye.
Thank you, sir. Thank you.
Thank you, sir.
Yeah. Thank you,
sir.
Thank you.
Sure.
Thank you, sir.
Thank you, sir.